believe I have a few minutes for questions, and I'd be glad to answer them. Goodness.
We're not letting you off the hook, that is. Hi, folks. I'm Adam Eisgrau. Thank you so much for being here this morning, and thank you to Hina as well. Hina, tell us a little bit more, if you would, about these confusing program names that people hear. Folks in this room may have paid attention to the revelations from whistleblowers and others over the last year. PRISM, Upstream. Upstream is now called something else. PRISM is called something else. Downstream, very clever.
So you all know Adam, and I'm going to do, what sometimes people do to me, which is, Adam, you're an expert on these issues. And you're going to be talking about them. So do you want to start and we'll have a conversation?
Well, I suppose we can. Let's broaden it out a little bit. So this notion of mass surveillance, folks in this audience have heard we at ALA in Washington, otherwise at prior alleged days, talking about bulk collection, mass surveillance. And a number of people in the audience, if I were in the audience, I would be thinking, wait. We had this whole big Section 215 fight. Didn't we end bulk collection? Isn't what that was all about? You said we still have mass surveillance. How's that happen?
Right, so Section 17 was just a very particular authority that was put in place in 2001 with respect to particular kinds of records. When after President Bush's warrantless mass surveillance program was revealed as a result of public reporting, instead of reining it in, Congress passed Section 702 of the Foreign Intelligence Surveillance Act's amendments in 2008. And 702 supposed to be pretty restricted, right, in some ways, but what it actually does and what it was set out to do as government officials essentially admitted at the time, was not to be limited to targets that are solely foreign and solely abroad, as traditional FISA had done. And it was not to be restricted in terms of the kinds of constraints and safeguards, including probable cause requirements. And it was not to be restricted to people abroad. It was very much meant to sweep in Americans' bulk records of particular kinds, including especially those that travel over the internet. And so these are the authorities that have been put in place, that have been abused, that continue to be violated with respect to the Constitution. And we've brought challenges, right? We've brought challenges under the Fourth Amendment, under the statute as well, and we're waiting for those challenges to play out in the courts. But if there's anything that all of us know, it's that sometimes courts can take a while, and that court cases require also broad support. I'm not sure that we would have had as quick or as great a response, for example, to our Muslim ban cases had we not have tens of thousands of people coming out across the country essentially saying this is not who we are, this is not what we are. So part of the efforts that we're talking about here with respect to 702 and the different kinds of programs that exist under it is the kind of debate that is going to take place later this year, and the ways in which those reforms need to take place to ensure that unlawful searches, retention, collection, and use of information does not return or expand.
So we hear about this incredible technology the government has. Now, you couldn't possibly, I mean, give me a break, you couldn't possibly listen in to the entire internet, could you? He said leadingly, knowing the answer to the question.
You can, and they do, and that's the short version of this. And among the challenges that we face in legal arguments and litigation, but that it's also important to know, is that the government says, well, mere collection doesn't violate the Fourth Amendment. It's only when we use it that it violates the Fourth Amendment. To which we say, well, give me your diary. my mere collection of it won't violate your privacy rights. And just trust me to keep it under lock and key. And maybe I'll tell you if I open it, maybe I'll provide you notice, but usually I won't. How does that make you feel?
You know, these lefties go way overboard, don't they? I mean, you know, we don't have to trust them. We have a court overseeing this entire national security apparatus. Aren't you forgetting that? He said, knowing the answer to the question.
I know, I think this is slightly unfair. I want to know whether other people have questions as well. So I think, you know, one of the key Snowden revelations was the confirmation of something that I think many of us had suspected, which is that this court, which had been set up, and you know, you will all know, and if you will know that this was part of the reforms put in place by the Church Committee, right, which had undertaken an investigation and found that over decades the intelligence community had been collecting information of Americans' information using the technology then available in violation of Americans' rights. And what had resulted was a set of reforms, including the Foreign Intelligence Surveillance Act. This was supposed to be a restrictive measure. It's now turned into a permissive measure, right? And part of the struggle that we've had ever since '76 and so on is to go back to and have this tussle back and forth with the government with respect to our fundamental argument that safety and liberty have to go hand in hand. You cannot have a balance where you let one go with the other, because that's quite simply always going to result in the kinds of violations that the Church Committee found. And so one of the reforms that was put in place was to have the Foreign Intelligence Surveillance Court. But this court was meant to do something very specific, which is to look at warrants and to review information that was based on a standard of wrongdoing being found, and with respect to particular targets, not entire programs. But among the things that became very clear as a result of the Snowden disclosures was that the court had been requested by the Bush administration and had gone along with essentially secret interpretations and reinterpretations of critically important provisions of FISA and constitutional interpretations, and we didn't know. We didn't know. Among the reforms that were put in place by USA Freedom was a requirement, or sort of essentially, you really have to tell us when you're going to arrive at novel and significant decisions. But that's been pretty imperfect still. And so much of what's been made public, and we're continuing to fight to have more made public through Freedom of Information Act requests and requests to the court itself, is so redacted or so imperfect that we really have very little information. And we still don't know, as I was saying earlier, whether the new announcement from the NSA results from a still secret order that we should know, right? And so where we are still is in the midst of this very necessary debate where our rights are still being violated, where privacy and the access to privacy rights and access to really intimate information about us that the government may now have and store, and a deeply flawed system of oversight. And that's what I think faces us.
Aren't we lucky she's on our side? Hina Shamsi. I'm going to do something my staff is not going to understand at all, which is actually stay on time. It's just about 10 o'clock. A quick reminder that we'll be taking a 15 and only 15-minute break. Actually, I tell you what, we're going to take a 13-minute break. I'm lying. Please be back here at 10:15. We've got 6 presenters, 10 subjects to cover, and a lot to rock and roll on. If you've got questions about any of this or anything else, you know how Lucy mans the little stand and it says the doctor is in? we have Emily Wagner, our terrific information manager in the Washington office. You can tweet her a question at #NLLD17, and magically you will get an answer. See you all back here 10:15 sharp.